Thank you, Representative Ramos. And Representative Ramos is correct. You know, the records that we keep as public servants belong to the public, and we have an obligation to make sure that we're safekeeping those in a responsible way that's accessible to them, and so that they can see what we're up to here in Columbus. You know, the issue of having public records easily accessible to journalists and the public, and having a process for those records that isn't burdensome is fundamental in ensuring a fair and open democracy. Public records law are meant to be a tool of public accountability for our elected officials and governments, and as employees hired by the taxpayers, we should be working to ensure that they have every tool at their disposal to judge us according to our actions. The only way to gain access to public records right now, if they're not readily provided by a public department or official, is to file a petition for a writ of mandamus in court. But our goal should be to avoid costly and lengthy court proceedings for the taxpayers. It's time that Ohio join the rest of our nation in ensuring that taxpayers really do have the right to know how their government works. That's why we are proposing that Ohioans get their questions answered in 20 days. Not just a thank you for the request letter, and we'll look into it, but real answers, the information that matters to taxpayers. This small step would ensure that Ohio is in line with the relatively relaxed standards of the Freedom of Information Act. If the federal government can get you the information that you request within 20 days, then so can the state of Ohio. We should do what we can to lessen the burden on taxpayers when Columbus bureaucrats force expensive legal battles. And one way to do this is by creating an independent public records ombudsman. A public records ombudsman would be able to participate in dispute resolution, offer informal and formal advisory opinions when complaints are made, educate the public, government officials, and the legislature. Obviously, the Attorney General has an inherent conflict of interest in dealing with any state public records disputes. We should take this out of his office, put it in the hands of an independent public records watchdog. Finally, the Ohio Supreme Court recently issued a ruling in a 6-to-1 opinion that the current language of the Ohio Public Records Act would not allow for the award of attorney's fees in cases unless the release of the record was previously ordered. In the words of the lone dissenter, Justice Sharon Kennedy, it would allow a public office to sit on public records request until a case was filed and then turn over the records before the court had a chance to issue an order. This is a huge roadblock to anyone trying to obtain public records from unwilling officials, and it needs to be fixed. We don't want to allow public agencies to simply delay and stall until they're on the heels of a potential court order and then make those records available. And the other part of that is that it would discourage people from being able to file these actions and get the records that they seek as well, because attorneys may be unable to take these cases if there's no possibility of recovering attorney's fees in these cases. So, you know, these are things that we intend to work on, and I appreciate you being here. I'm going to turn this over to Representative Carney, who's going to talk to you